Great evening. My name is PJ Lucky, and I serve as a minister at Triumphant Christian Church. We want to thank you for joining us in our Capacity Building 2020. Tonight's session is Tenants Know Your Rights. We have a special guest who will be discussing fair house laws, landlord abuse, rent control, security deposits, and COVID executive orders by our governor. Tonight's special guest is Anna Keegan. Anna Keegan works as the acting director for the City of Norwalk's Human Relations and Fair Rent Department. In this role, Ms. Keegan investigates and mediates fair rent and human relation complaints. And when necessary, she prepares cases for hearing. Ms. Keegan also answers questions for the public on a variety of employment and rental issues and serves as the city's ADA coordinator. Ms. Keegan is a licensed member of the Connecticut Bar. She earned her undergraduate degree from Louisiana State University and graduated summa cum laude from Quinnipiac University School of Law. Thank you so much for joining us. Thank you, Ms. Keegan. We welcome you on tonight's panel. Thank you.
Thank you so much for having me, and good evening, everyone. I hope you're all having a great evening tonight. What I'd like to do is I'm going to start off by covering some of the special things that have come into effect since COVID began. And then after I've covered those, I'd like to go into the basics of the landlord-tenant relationship, starting from looking for tenants and ending at eviction or moving out, hopefully the latter. One thing I really want to emphasize before I say anything else, if you take anything away from this tonight, please take away that you can call and ask questions. I'm going to be covering the most basic of information, trying to hit on the issues that most people tend to have trouble with, but it is very basic, and I'm happy to answer any questions about landlord-tenant rights and responsibilities that anyone has, and please call if something comes up. That said, let's talk about COVID. Right now, there have been a variety of different orders from the federal government and the state government and some agencies. Right now, 2 are in effect that apply to Connecticut citizens. The first one is Governor Lamont's executive order. Throughout COVID, Governor Lamont has issued several executive orders that affect the rights of landlords and tenants, mostly to protect tenants from evictions during COVID. Currently, the most relevant one, because most of the other protections against eviction have expired, is his Executive Order 000. He's gone through a lot of executive orders. This executive order states that tenants cannot be evicted until October 1st, except for one of 3 reasons, which have to be stated on the notice to quit in order for them to apply. The first reason is if the tenant owed rent as of the end of February, they can be evicted for non-payment of rent only if they owed rent as of February. If they were paid up till then, they can't be evicted until October 1st hits. The second reason is if the landlord intends to live in the home for their own principal residence. That means the landlord must intend to move into the home and must say so on the notice to quit in order to evict the tenant. The last reason a tenant can be evicted is for what we call serious nuisance. That means the tenant is engaging in one of several serious criminal behaviors, either threatening the landlord or other tenants with serious bodily harm with some degree of immediacy, selling drugs out of the premises, or engaging in illegal sex work out of the premises. It's a pretty limited list. You're not going to see too many serious nuisance evictions, but they can go forward as of now. The second thing that executive order did is it gave the ability for tenants to use part of their security deposit as rent for September. Previous executive orders had allowed this for previous months. This is just adding September to the list of months this is allowed for. Now, to explain that, I'd like to say that normally it is not legal for a tenant to use the security deposit as rent. Under normal circumstances, a tenant who uses the security deposit as rent can be evicted for non-payment of rent. What this executive order does is it says that a tenant who has a security deposit of more than 1 month's rent can tell the landlord in writing that their income has been affected by COVID and they would like the landlord to apply the amount of the deposit that is over 1 month's rent towards September rent. If the security deposit is 1 month's rent or less, this doesn't do them any good. But for a tenant who has more than that for the security deposit, they can use it as September rent, and the landlord can't make them repay it until either the end of the COVID emergency or the end of the lease, whichever one comes later. So that's Governor Lamont's executive order. That one's going to end right now on October 1st, but hopefully we will get another one that will give us a little bit more time, because I don't see this ending anytime soon. The second one I want people to be aware of, you may have seen in the news, the Center for Disease Control issued an order banning evictions under certain circumstances. I'm not going to go into all the circumstances tonight, because all the conditions, because it's a pretty long list and I want to get to other things. However, here's what you need to know. First, this only applies to evictions for non-payment of rent. Second, in order for it to apply, the tenant needs to print out the declaration form that is on the CDC website. I'm happy to provide a copy to anyone if requested as well. They need to have every adult in the household sign it under penalty of perjury, and they need to give a copy of the form to the landlord. The form is going to list all the conditions that the tenant has to swear to be true. Here's the main ones you need to know about. The tenant needs to say that they have made efforts to try and get government assistance for the rent. Even if they haven't been able to get it, they need to say they tried. So what I'm recommending tenants do who are trying to get this protection is take notes. Call 211, ask if they can send you to government assistance, write down the date, who you talked to, and what the results were, and any other efforts you made to get government assistance on a piece of paper, and then put it in a folder. So if you need to prove it like that later that you tried to get government assistance, you've got it right there. The second thing they need to show is that they've lost income due to COVID. They also need to make under $99,000 a year, but I don't think that's going to be too much of an issue for most people. Lost income due to COVID can either be lost wages or significant out-of-pocket medical expenses that are going to equal 7.5% of their expected annual income. The third thing they need to have done is made partial payments of rent. That means the tenant has to try and pay something even if they can't pay the full rent. It doesn't give any guidance for what the partial payments ought to look like. What I tend to do in these situations is look to what other federal agencies are doing, which means HUD has always had an affordability standard wherein 30% of your income is considered to be an affordable rent. So what I'd recommend tenants try and aim for in partial payments is 30% of whatever their current income is. The tenants need to know rent is still due. At the end of this protection period, rent will still be due. Tenants who don't pay rent can be evicted for non-payment of rent. Their landlords can sue them for the rent in small claims court if they so choose. And it's still going to be due. What the CDC protection does is says they cannot be evicted until December 31st if all these conditions are true and they give their landlord the signed declaration saying so. There's some pretty serious penalties for the landlord violating this order. Landlords who begin an eviction anyway can be subject to a fine of up to $100,000 or a year in jail. So I'm hoping we won't have too many issues with violation. However, everyone should be aware of these protections and have everything documented in case they do end up going to court. That is basically what I have for COVID-specific protections. Before I go into the more general landlord-tenant rights and responsibilities, I'd like to open it up for any questions anyone has just on this COVID section, and then I'll move on. Okay. I'm not hearing any questions. If any come up later, okay. If any come up later, I'll be happy to answer them at the end. So, going on to the question of starting the landlord-tenant relationship. The first thing you have is on the tenant side, looking for a place to rent. On the landlord side, looking for tenants who they will trust with their apartment. In this situation, the main thing everyone needs to know is the anti-discrimination protections for tenants in rental situations. It is important for landlords to try and treat everyone the same, because that means You can't accidentally discriminate, and you can't deliberately discriminate if you apply the same conditions to everyone across the board as to who you will rent to, who you won't. It is legal for landlords to do things like have credit checks, have criminal background checks, just decide they don't like the color of someone's shoes. All those things are legal. However, landlords cannot discriminate against tenants based on their membership in several protected classes. Now, some of them we all know: race, gender, national origin. Some of them are a little less known. You cannot discriminate against someone based on their religion in renting. You can't discriminate against someone based on their marital or family status. That means whether or not someone is married or whether or not someone has children. You cannot refuse to rent to people who have children. You cannot discriminate in Connecticut against a tenant based on their sexual orientation or their disability. You also can't discriminate against someone based on their gender identity or expression in Connecticut. Now, that one I'd like to go into a little bit more because most of these categories we're aware of and familiar with. Gender identity or expression is a little bit less familiar to a lot of people. It means you can't discriminate, one, against trans or non-binary people, or two, against anyone because you don't like the way they're presenting their gender. For instance, if a man wants to wear a skirt, you can't discriminate against them because that's how they're choosing to present their gender. A good rule of thumb on this one is listen to the person you're talking to. In order to avoid this sort of discrimination in what is a relatively new category to a lot of people, it's important to pay attention when someone tells you what their pronouns are. If they want to be called she, her, you call them she, her. If they want you to use they, them pronouns, you call them they, them, and you don't have an argument about it being grammatically correct. Same thing goes for names. Even if they have a legal name that is different, you call them by the name they ask to be called. And that's one of the best ways you can avoid accidentally discriminating against someone based on that particular protected class. And also, don't ask intrusive questions about anything related to that. As far as criminal background checks, it is currently legal to refuse to rent to someone based on their criminal history. There has been some movement in the legislature looking to limit that to a certain extent. So while it is right now legal, I would keep an eye on what the Connecticut legislation happens because it might later become illegal. Before I move on to discussing lease terms, any questions about when you're anti-discrimination protections and who you can rent to and who you can't? Okay, the other thing I want to say about anti-discrimination protections is sometimes it's hard to tell when you're experiencing discrimination or not. And we have a couple of very good agencies in Connecticut that do testing in order to determine if there actually is discrimination going on. So if you think something's odd, call the Connecticut Commission on Human Rights and Opportunities and call the Connecticut Fair Housing Center. Also call them if you actually have experienced discrimination. They are both wonderful organizations full of people who can really help. All right, so once you've decided the tenant wants to rent from the landlord wants to rent from the tenant, the next question is the lease. It is very smart to always have a lease. Leases give everyone a good idea of what their rights and responsibilities are and do it in writing. A lease doesn't have to be for a year. If you and the landlord want to have a relationship with a month-to-month rental agreement, you can still have a lease that says this is a month-to-month rental and lays out who's responsible for what utilities and all other terms like that. A lease is always a good idea to have. Some terms in a lease that often come up are late fees. If you do not have a lease, you cannot be charged late fees. In Connecticut, there are also limitations on what late fees can be charged. A landlord cannot charge constantly accruing late fees. So a late fee that is $10 a day until whenever you pay, and if you keep never paying, it keeps on being $10 a day. That late fee isn't legal even if it's in a lease that both of you signed. Late fees are limited to an amount that is non-punitive. Different courts have viewed that differently, but the usual range is somewhere between 5 and 8% of the rent is the maximum late fee that a landlord can charge. Even if a giant late fee is in the lease and everyone signed it, it still may not be enforceable in court. Another lease term that is commonly an issue is utilities. Landlords cannot make the tenant pay for utilities that are not separately metered for the tenant's use only. What that means is if you've got 2 apartments with 1 electric meter, you can't tell them you pay 50% of the electric. It is the landlord's responsibility to pay for 100% of the electric, unless there is a separate meter with only the tenant's apartment and nothing else, nothing from common areas, no shared areas on the meter. The same holds true for all utilities. If the landlord provides heat, it is the landlord's responsibility to keep the apartment heated at a minimum of 65 degrees year-round. There's no beginning date and ending date for when the heat has to be turned on. It has to be a minimum of 65 degrees year-round. So if we get snow in July, the heat has to be turned on at 65. That's actually one of the things that can be criminally charged, although I do recommend calling the health department before the police on that one. If the landlord does not provide the heat, the landlord is still responsible to provide an apartment that is capable of being heated at a minimum of 65 degrees. If the tenant chooses to heat it less, that's fine, but it has to be capable of heating to that amount. Another thing I want to get into is the security deposit, but before I do, because that's a whole other section, I also want to talk about reasonable accommodations. A tenant with a disability can ask the landlord for reasonable accommodations to change lease terms or some of the ways a landlord usually does things in order to accommodate their disability. Some common examples of that would be, for instance, agreeing to communicate by email rather than phone for someone who's deaf or hard of hearing, or agreeing to change how the tenant pays the rent if usually the tenant is supposed to drop off the rent at a location with stairs and the tenant can't walk up the stairs to drop it. In order to get a reasonable accommodation, the tenant should give the landlord in writing a letter saying they're a person with a disability. This is the limitations of the disability. They don't have to give the diagnosis, but a doctor's note saying what they can and can't do is helpful, and what reasonable accommodation they're asking for. The Connecticut Fair Housing Center has on its website a wonderful tool that helps people write reasonable accommodation letters, where you just fill in the blanks and it generates it for you. I really recommend it if you need to ask for any reasonable accommodation at any point in the lease. The other issue is reasonable modification. This is a tenant who moves in and needs a physical modification made to the premises. In such cases, the tenant is usually responsible to pay for things they want to do, like installing grab bars or a ramp. And they have to ask the landlord for permission in writing, same as a reasonable accommodation. But the landlord mostly can't say no. They can ask the tenant to restore the building to its original condition after they move out, and it is usually the tenant's responsibility to pay, but mostly the landlord has to agree to it. All right, so now I'd like to move on to the biggest lease term of all. Oh, I have a question. This is a question about if the lease runs out, if the landlord can raise the price of the rent if they haven't renewed the lease. I'm absolutely going to get to that a little bit later on. And I've got another question of whether you can be discriminated against for having a pet. And that is a great question regarding reasonable accommodations. A landlord can refuse to rent to someone who has a pet. However, a tenant with a disability who needs a pet for reasons related to the disability can ask for a reasonable accommodation of being allowed to have the pet, and the landlord usually has to grant it. This is a broader protection than just service animals. In housing, you can have more than dogs or miniature horses, which are the other sort of service animal allowed under the ADA. In housing, you can have what's called a comfort animal, where, for instance, if you have high blood pressure and the doctor says a purring cat is going to be helpful, that can be a reasonable accommodation that you can get in housing to allow a pet, even if the landlord usually has a no pets policy. Now, I am seeing the other question about rent increases, and I'm going to get to that, but first I'd like to finish up with lease terms before I do. The last term, and the one that tends to matter most to people, is security deposits because it involves a lot of money. A landlord is not allowed to ask for a security deposit that is more than 1 month's rent. Last month's rent is considered to be part of the security deposit. So if the landlord wants a security deposit and last month's rent, they can have 1 month security and 1 month last month rent. But they can't ask for 2 months security and last month's rent because that's more security deposit than is allowed under Connecticut law. If a tenant is over 62, the landlord is only allowed to ask for 1 month's rent security deposit. And if a tenant turns 62, they can write the landlord a letter asking the landlord to return the 2nd month of the security deposit if they paid more than 1 month's rent. What I recommend for people with regard to security deposits is if you have to move and you are not able to afford the full security deposit, sometimes it is possible to work out an agreement where you pay some of it now and you get a written agreement where you will pay extra each month until you've paid the security deposit. So you'll pay your rent and an extra $200 each month until the security deposit is paid. If you work out such an agreement, get it in writing, but that can be a useful method for people who are needing to move but having trouble with the full amount of the security deposit. What I recommend for people in order to protect the security deposits or in order to protect their house in the case of landlords is that everyone should take pictures before the tenant moves in. A landlord should take pictures of the empty apartment before the tenant moves in so they can establish what it looked like before. And a tenant, when they move in, should take pictures before they move their things in of the whole apartment so they can establish what it looks like before if they need to later prove that they didn't cause damage. A walkthrough is great. Do walkthroughs. They're wonderful things. They are no substitute for pictures. Pictures are the best possible evidence you can have, and everyone should take them whether or not they do a walkthrough. When a tenant moves out, the tenant and landlord should both also take a lot of pictures so they can show what it was like after they moved out. That way, if a landlord tries to say the tenant caused damage that they didn't cause, the tenant has pictures showing it. And if the landlord is trying to document that the tenant caused damage, pictures are a good way of showing that too. When a tenant moves out, they should give their landlord a letter using some form of mail tracking, either certified mail, return receipt requested, or priority mail. And in the letter, they should say, I moved out on this date. Please return my security deposit of this amount to me at this address. And they should give an address. They don't have to give their own address. If they're scared of the landlord for some reason, they can give a friend's address or a work address or a P.O. box, but they have to give some address. They should keep a copy of the letter for themselves, and they should print out the mail tracking because it disappears off the website after 45 days, as I have found out to my detriment. Once the landlord gets that letter, they are on a clock. A landlord has 30 days from the 30 days from the day the tenant moves out, or 15 days from the day they get the letter, whichever one is later, to either return the deposit or send a letter accounting for damages. That is a letter saying, this is how much your security deposit was, this is how much interest it earned, these are the damages beyond ordinary wear and tear that you caused to the apartment, this is the rent you didn't pay, here's a check for the remainder of the security deposit, if any. If the landlord does not either send that accounting or send a check for the security deposit within that 30-day timeline, the tenant can take them to small claims court and sue them for double damages. That means twice the security deposit automatically. And even if the tenant caused damage, that damage comes out of doubled the security deposit. So the landlord could still end up owing money. Because of this, I really recommend landlords, when sending this accounting, keep a copy for themselves and send it using mail tracking and print it out off their website. Security deposits can be charged for unpaid rent. They can be charged for damage the tenant caused to the apartment beyond ordinary wear and tear. Ordinary wear and tear is the sort of damage that you would expect to happen to the apartment from a normal person living there in a normal manner. For instance, you expect someone to have a couple of nail holes from hanging pictures in the wall, as evidenced by the one behind me. You do not expect fist holes in the wall. One the tenant can be charged for, the other one probably not. Same thing with carpets. Carpets are a great example because a lot of times, even if there's damage to the carpet that is beyond ordinary wear and tear, a giant wine stain, for instance, the landlord may not be able to charge for the cost of a new carpet. They can charge for the remaining value of the old carpet, which means if you have a carpet that was supposed to last for 10 years and it lasted for 7 years, the landlord isn't entitled to a new carpet, even if the tenant has caused damage beyond ordinary wear and tear to the old one. They're entitled to the remaining value of the old carpet. So take the price, divide by 10 years, and then multiply by the 3 years that are left. And that would be how much could be charged for the carpet. That's something that commonly comes up, so I want everyone to be aware of that particular issue. And that is the security deposit. Before I move on from that, I'm going to open it up again for any questions. Anyone have issues with the security deposit? What is the WCPA bill? I have a question. Do tenants have to pay for the WCPA bill? And I am not familiar with this acronym. Okay, that is the Water Pollution Control Authority sewer. Sewer is considered a utility, so tenants can be charged for the sewer cost if it is separately metered for the tenant's use only. That would probably mean single family, yes, multifamily, it's more of an issue. I'm not entirely sure how the sewers are usually billed, but if it's separately metered for their use only, yes, they can be charged, otherwise maybe not. Any other questions? Okay, so let's talk about what happens while the tenant is in the apartment once all the lease terms have been set and agreed on. We had a question about rent increases earlier, whether the landlord can increase the rent for a tenant who is living month to month if they haven't renewed the lease. I suspect this question is someone who has one of the big company landlords, because it's pretty common for the big company landlords to have something where you either sign a new year lease or you go on their month-to-month rate, which tends to be a significantly higher rate. And the answer to that question of whether or not they can do that is maybe. If a tenant lives in a town with a fair rent commission, then the tenant who has an increase that they think is unfair has the right to file a complaint with the Fair Rent Commission saying the rent increase is unfair. What happens then is the Fair Rent Commission can look at a list of 13 factors to decide if the increase is fair or unfair, including what's being charged in similar apartments in similar neighborhoods, how big the rooms are, what amenities are included, the tenant's income. There have been cases where a low-income tenant was found to, an increase on a low-income tenant was found to not be allowed, even though it would otherwise be okay. The landlord's expenses, the extent to which the increase is going to be reinvested in the property, and any repair issues. Based on these factors, a Fair Rent Commission can determine what the rent should be and order that to be the case. If you live in a town without a Fair Rent Commission, one, you can ask the town to make a Fair Rent Commission, which might be helpful. And two, mostly you're out of luck, unless you're a tenant over 62. A tenant over 62 who has a rent increase that they think is unfair has the right to file a fair rent complaint with the court. And the court would use that same list of 13 factors in order to decide if the increase is fair or unfair, and then the court would set the amount of the rent. If a tenant is an over 62 and they live in a town without a Fair Rent Commission, there's not much protection as far as rent control in Connecticut. Connecticut rent control is Fair Rent Commissions, and that's basically it. Now, there's a couple of other things that tend to happen during the course of a tenancy. One we're getting a lot of questions about right now is landlord entry. The law says that a landlord cannot come into a tenant's apartment without their permission, except in an emergency situation like a fire or a pipe broke or something that requires really immediate action. Otherwise, the landlord is required to give the tenant reasonable notice, which is usually taken to mean at least 24 hours notice, and the tenant can say no. The tenant is required to allow the landlord reasonable access at reasonable times with reasonable notice, which means the tenant can say, no, not this time, but they can't say no, never. They can say, not this time, but I am available these 3 other times. And what I recommend for tenants who are saying no to a specific time is when you say no, also offer 2 or 3 other times when you are available to make it clear that you are offering reasonable access. I'm getting a lot of questions lately about entry during COVID, mostly from tenants who have illnesses that are particularly afraid of exposure. And I don't have a good answer. The law says a tenant cannot unreasonably refuse the landlord access. I don't know what the courts will consider unreasonable in the time of COVID. It's possible they might consider it reasonable for a tenant with serious lung conditions to refuse entry altogether or refuse entry without a mask. It's possible they won't. This is one of the many fun areas where COVID is giving us no answers whatsoever and won't give us any until after it's probably too late to be helpful. If a landlord goes in without a tenant's permission, except in an emergency situation, the tenant can sue the landlord for an injunction ordering the landlord not to come in anymore and for damages at a minimum of 1 month's rent. They can also call the police because coming in without the tenant's permission in a non-emergency situation is criminal trespass. It doesn't matter that the landlord owns the property. They have rented it to the tenant and the tenant has the right of exclusive control. If a landlord is having trouble getting into an apartment, the tenant is denying them reasonable access. The landlord can take the tenant to court and sue for a court order telling the tenant to let them in. If the landlord wins that lawsuit, they can get damages of attorney's fees and any money they have lost based on the tenant denying them access. There's a couple of other things that often come up over the course of the lease. Another one is repair issues. Who has to pay for repairs? What do you do if your landlord isn't making repairs? A landlord is mostly responsible to pay for repairs. Unless the tenant or the tenant's guests have caused the damage, it is the landlord's responsibility to pay for any repairs that come up. If the tenants or their guests have caused the damage, for instance, punching a hole in the wall, it is the tenant's responsibility to pay for the repairs. The landlord can still be the one to choose who the contractors are going to be and then charge the tenant for the cost of the repairs. They don't have to let the tenants make the repairs themselves, but the tenants, if they cause the damage, are the ones who have to pay for the damage. If you have repair issues and your landlord isn't fixing things, one of your best possible calls is your city health department. Health departments can come out and inspect, and if they find there are health code violations, they can order the landlord to fix things, and they have ways of enforcing that you do not have. It is almost never a good idea to stop paying rent because of repair issues. If you stop paying rent, you can be evicted for non-payment of rent, even if there's repair issues, unless those repair issues are so serious that a judge considers the apartment uninhabitable. It is much, much safer to call the health department or call the health department and then if they still don't fix things, file a case in court where you pay rent into court instead of to the landlord, than it is to just stop paying the rent. That's the most dangerous way of handling things for your own housing stability. If you live in a town with a Fair Rent Commission, you also may be able to file a complaint with the Fair Rent Commission saying that because the landlord isn't making repairs, the rent is unfair. If you don't live in a town with a Fair Rent Commission, that doesn't apply so much. The only exception to this, tenants have to pay for what they caused rule, is bed bugs. Connecticut recently passed a law specifically dealing with bed bugs and who is responsible for what. In that law, if a tenant reports bed bugs, the landlord has a very fast timeline on which they need to come out and inspect and treat. If the landlord is solely responsible for paying for the treatment costs the first time around, it doesn't matter if the landlord saw the tenant bringing in a mattress that was marked "bed bugs don't take." the landlord is responsible under the bed bugs law. The tenant is responsible for preparing the apartment for treatment. That means if the bed bug company says, pull everything away from the wall and wash all your sheets, the tenant has to do that, and the tenant is the one responsible to pay. I get that question a lot, especially from housing authorities, where the tenants can't really afford the laundromat. It's still the tenant's responsibility. If a tenant is physically incapable of preparing the apartment for the treatment, the landlord can make a deal with them where they will hire someone to do it or do it themselves, and the tenants will pay the cost on a payment agreement of the work to prepare the apartment for treatment. The only time when a tenant can be charged for bed bug treatment is if during the first treatment, the tenant unreasonably failed to comply with the necessary measures to prepare the apartment for treatment. Not just didn't do it, unreasonably didn't do that. So that is the only circumstance under which the tenant can be held responsible for bed bug treatments. Otherwise, that is completely the landlord's responsibility. And there are also, for both any going to the health department or Fair Rent Commission or any complaints about bed bugs, anti-retaliation protections. There are 2 laws in Connecticut that protect a tenant who goes to the health department or complains about a major repair issue to the landlord. The first one says that a tenant cannot be evicted or have their rent increased within 6 months of asking for an important repair or going to any city department regarding a repair in good faith. The second one, the only exceptions to that are if the tenant doesn't pay rent. So again, don't stop paying your rent because of repairs. If the landlord asks the tenant to leave prior to the tenant making the complaint, if the landlord wants to live in there for their own home, or if the tenant is using the apartment for sale of drugs or illegal sex work. Other than that, that protection applies. After that 6-month protection period applies, the landlord is still not allowed to evict the tenant to punish them for asking for repairs, but it becomes the tenant's responsibility to prove that the landlord is evicting them because they asked for repairs rather than for some other reason. It's not a gimme anymore, the way the first one is. Common areas are always the landlord's responsibility. Snow removal, keeping common areas clean, that's the landlord's responsibility to take care of. However, the landlord can pass off that duty to the tenant. What I recommend for landlords doing that is in the lease say that it's being passed off and maybe give a compensation for it. The rent is reduced by $20 because the tenant agrees to handle snow removal, sort of thing. That way it's clear that it's being passed off and that everyone is aware of who the responsibility belongs to. What I generally recommend to people with regard to rent increases generally is it is smart for landlords to do small increases to keep the apartment at market rate rather than to let the apartment sit without any rent increases for 5 years and then just suddenly increase the rent by $300. Most people aren't going to be able to afford that sort of a rent increase. It's bad for the landlord-tenant relationship, and it puts everyone in a worse situation. I also recommend everyone communicate about rent increases. A good tenant who takes care of your apartment and pays your rent on time, that is an invaluable thing to have. Anytime a landlord is getting a new tenant, they're taking a risk, which means it may be worth it to a landlord who wants a rent increase to work with a tenant who can't afford that rent increase, or to take a lesser rent increase, or none at all, because that tenant is taking care of the apartment and reliable and quiet and pays the rent on time. Communication benefits everyone, and openness to negotiation benefits everyone. Any deals you get, make sure you put them in writing, signed by everyone. But communication can solve a lot of issues. Even if the communication is just, I'm working on it, or here's why I really need this, that can make a difference. Because otherwise, people are just left with commands that they don't know why they're happening. I've already discussed fair rent complaints and filing complaints with court if you're over 62 in a town with a fair rent commission, so I'm not going to go over that again. So are there any questions about any of that before I move on to the most depressing part of this, which is eviction? Okay. So, oh wait, I've got a question. Can we still sue if they waited months to fix the mold in our home, but we had proof that they fixed other tenants' homes and used COVID as an excuse of why they couldn't help us sooner? Yes and no. COVID, I don't know how courts are handling COVID. COVID is something that we're going to find out how courts handle it after it's too late for me to give any definitive answers, because probably it'll be over at that point. However, if there are health code violations in the apartment, which mold may be, you can always call the health department out, and they can always order the landlord to fix things and give them a timeline on which to fix them. So if you have a landlord not making repairs, the health department is always a wonderful first call. As far as suing, if you want to sue a landlord for not making repairs, what you have to do is call the health department out, wait 21 days, inform the landlord in writing when you call the health department out about the issues, wait 21 days from that, and then you can file what's called a rent into court case. That is a case where you are suing the landlord to make repairs, and you tell the court, I want to pay rent into court instead of to the landlord. That way you are still paying rent, so you're not going to be evicted for non-payment of rent, but the court has the money, not the landlord. And when it goes to a hearing, the judge can order the landlord to fix things, and the judge can also decide if you should get some of your rent money back because the landlord wasn't making repairs. You maintain that right during COVID. I don't know how the courts are going to handle it as a defense, but everyone still has the same rights to repairs and to live in apartments that do not have health code violations as they did before COVID. And I don't think health departments are saying you don't have to do anything, although it might stretch out the timeline slightly, but we're not entirely sure how that's going to be handled in the event in COVID, but you still have the same rights. Okay, if there are no other questions, eviction. Before I start with eviction, I'm going to talk briefly about abandonment. That's where a tenant breaks the lease and moves out. In those circumstances, the landlord has a duty to try and re-rent the apartment. If the landlord does not make reasonable efforts to re-rent the apartment, the tenant doesn't have to pay rent after they move out. If the landlord tries to re-rent the apartment and fails, then the tenant has to pay rent until either the landlord finds a new tenant or the end of the lease, whichever one comes first. It is wise, if you are going to break the lease and move out early, to get something in writing releasing you from the lease, signed by the landlord if possible. If not, there's certain other ways to be released. If you have a repair situation, give me a call, we can talk about it. Otherwise, if a landlord thinks a tenant has abandoned an apartment, they can't just walk in. The only circumstances under which a landlord can go in is if the tenant has removed substantially all their possessions and either said they're going to move out by a specific date, which is now passed, or not paid rent for 2 months, and the landlord has done certain follow-up. Otherwise, the landlord still has to go through the eviction process. Landlords always have to go through the eviction process to get the tenant out. Things like turning off the utilities, changing the locks, throwing a tenant's stuff out on the street, these are all called self-help eviction. They are all illegal, and they are all things that the police can be called for. In the case of utilities, I tend to recommend the health department if they're open, but you can call the police, and on evenings and weekends when the health department isn't open, the police are the third people to call. The way eviction works is first the landlord needs to serve the tenant with what's called a notice to quit. It needs to name all the adults in the household. If they don't know the name, it's John Doe or Jane Doe. And it needs to list the reasons for the eviction. The reasons for eviction are things like non-payment of rent, lapse of time, which means your lease is up and I don't want to rent to you anymore. Person who once had a right or privilege to occupy no longer has that right or privilege, which means I didn't really rent to you, but the person I rented to let you stay and I want you to leave. There's also serious nuisance, which is criminal behavior, as I've discussed before. Most notices to quit will have what I call use and occupancy language on them. That is something underneath the reasons that says something along the lines of Any rental payments will be accepted for use and occupancy only and not for rent, with the full reservation of the right to continue with the eviction action. What that legal language means is, if you pay rent, I can take your money and still evict you. If a tenant gets a notice to quit, they should make sure there's not use and occupancy language before paying rent. If there is use and occupancy language and you want to pay rent, you need to get something in writing signed by the landlord saying you are now a tenant in good standing again, to protect you from having the money taken and the eviction still happening. A notice to quit usually gives a minimum of 5 days to get out. A lot of people get that and think they have to be out in 5 days. That is not the case. If you are not out by the date given on the notice to quit, nothing happens except more paperwork. The next set of paperwork is a summons and complaint. On the top right-hand corner of that, there will be a return date. By that day or 2 days after, the tenant needs to go to court and file an appearance and an answer. The court forms on eviction are actually pretty easy to work through. You agree or disagree with each of the numbered paragraphs in the landlord's complaint. And then there's a list of special defenses. So you check off any special defenses that apply. And then at the bottom of something else going on that you think the court should know about, you write that or ask for more pages to write on if you run out of room. Once the appearance and answer are filed, the tenant and the landlord will get a hearing date. On that date, they'd go to court. They would meet with a housing mediator, which is a chance to make a deal. Any deal made with the housing mediator becomes a court enforceable order. It also shows up on the tenant's credit and harms their credit the same as an eviction does. I don't necessarily think that's particularly good policy, but that's how it works right now. If they can't make a deal with the housing mediator, they'll go in front of a judge. The judge will decide if they should be evicted or not based on the defenses and the arguments in the case. Even if the judge decides they should be evicted, the tenant will have a few days to apply for what's called a stay of execution, which means more time to stay in the apartment. In a non-payment rent case, the judge has the power to give up to 3 more months to stay in the apartment as long as the tenant pays all the rent that's owed and rent for those months. Mostly that doesn't happen because in non-payment of rent cases, mostly the tenant didn't have the money to pay the rent to begin with. In lapse of time cases, where it's just the lease expired and the landlord didn't rent to the tenant anymore, the judge has the power to give up to 6 more months as long as the tenant pays rent. I'm emphasizing the fact that the judge has the power to do this because having the power to do it doesn't mean they will. It means they can. The judge decides in each individual case whether they're going to give any time, and if so, how much. Factors like, they may consider factors that are not otherwise relevant to the eviction, like having children or having a disability making it take longer to find a new apartment, or even right now, possibly COVID making it harder to find a new apartment, in determining whether to grant the stay and how long of a stay they're going to grant. Once whatever time the tenant has is up, the landlord would have to schedule the eviction with, in our city, it's the health department, but whatever city agency handles it. A marshal would come out and put a 24-hour notice on the tenant's door. At that point, a tenant should grab all their important documents and make sure they're out of the house so they don't lose them. If the tenant's not out within 24 hours, the marshal will come and take the tenant's things and put them in storage. The tenant can get their things back out of storage by paying the storage fees within 15 days. Practically, they're often kept longer than that, but 15 days is what's allowed by law. And that is eviction. I have finished my presentation, but if there are any questions about eviction or anything else, I just want to conclude by saying this was a really overview. There's a lot more going on in this law, and if anyone has any questions or a situation that comes up, please feel free to call me. My number is 203-970-4200. You can't file a fair rent complaint with me if you don't live in Norwalk, but I will answer brief questions about anything that comes up. So, any questions?
And I believe that's, I don't see any questions currently.
Okay, well, thank you so much for having me. I hope everyone feels free to call if any other questions come up.
Awesome. So actually, I just put Ms. Keegan's phone number in the chat, so in our comment section. So feel free, as she mentioned, to reach out to her. Ms. Keegan, again, we appreciate you taking this time to provide our community with this great information. I'm sure many tenants have a greater understanding of their rights.
I certainly hope so.
Thank you so much.
All right, thank you.
To our viewers, we encourage you to follow our Triumphant Christian Church Facebook page to stay abreast of this next month of capacity building. We will be streaming a variety of sessions to enhance our community. So remember, follow us, like us, and share us on Facebook, and subscribe to our YouTube page. Thank you so much. Enjoy.